Greetings at Cheating Story Lab. Share your location, and let's dive into today's tale. This story unfolds where cunning strategies collide with treacherous deception, revealing that the one who believes they wield all the power often finds themselves unaware of the game being played. I am David, recounting the narrative of how my wife's scheme to financially undermine me backfired disastrously upon her. This is a tale encompassing trust, deceit, and the potent influence of information that transcends 3 generations within my family. Initially harboring vague doubts, we were eventually propelled into a courtroom with an unexpected twist. I encountered Amber 5 years ago at a charity event in downtown Chicago. She was captivating, with her blonde hair, ambition, and serving as a marketing director for a renowned company. Her allure was instant, drawing me in with her intelligence and charisma. At 32, I had established a good life for myself, or so it seemed to others. I owned a respectable car, resided in a spacious apartment, and worked as a financial advisor. To onlookers, I projected an image of success without wealth, a facade deliberately maintained. Amber, among others, was unaware that my roots were embedded in substantial family wealth. My grandfather had fashioned a manufacturing empire in the Midwest, and his death 10 years prior left behind an intricate trust system meant to safeguard our wealth from individuals like Amber. Overseeing this trust was my grandfather's long-standing lawyer, Harrison Mitchell, who had been acquainted with our family for 4 decades. According to my grandfather's instructions, I received a steady income that seemed substantial but paled in comparison to the untouchable assets, the manufacturing enterprises, real estate holdings, and investment portfolios worth over $8 million, which remained off-limits until my 35th birthday or marriage to someone who had undergone thorough scrutiny. My grandfather had witnessed numerous family fortunes being squandered by fortune hunters and divorcees. Built fortified terms into each contract, I had dated Amber for 2 years prior to proposing. Over this period, I developed sincere feelings for her, or at least the version of her I perceived. She appeared to love me for who I was rather than my wealth, since she was unaware that I held a well-paying job. Upon our engagement, I disclosed certain financial details due to Harrison's insistence on a prenuptial agreement. I informed Amber about some family funds totaling approximately $500,000 spread across various accounts, and requested the prenup for mutual protection. She signed without significant resistance, stating her own career was sufficient and she didn't require my finances. This 43-page legal document, crafted with meticulous care by Harrison, offered top-tier protection, using language that appeared routine but concealed critical clauses. Amber's attorney perused it briefly for approximately 2 hours, while Harrison had labored over it for 2 months. Our wedding was exquisite. 200 guests gathered at a suburban club for Amber's family's arrival from California, an event I had shouldered the cost of, explaining savings and assistance from relatives as sources. In truth, the trust managed all expenses, although Amber perceived we depleted our reserves on the festivities. The initial 3 years of our union were blissful. Amber rose through her career, reaching the position of a senior director. I procured a house, listed under my name but within the confines of a trust framework. The mortgage remained credited to me. We enjoyed a social life, hosted friends, cultivated an appearance consistent with upper-middle-class existence. I ensured not to display affluence beyond our joint income's explanation. Our home was comfortable yet restrained. Our vehicles were good but not lavish. Expensive vacations were justified by bonuses or family presents. However, alterations in Amber surfaced in the 4th year. Initially, it were casual remarks. She would bring up couples we knew who resided in larger homes or drove luxury vehicles. She'd indicate costly goods in stores and express wishes for the day when we achieve great success. She gradually urged me to take bolder steps with my career, suggesting I establish a consulting firm. Think grander. The topic of family wealth soon emerged. One evening during dinner, she suggested that my grandfather had left more than I'd disclosed. Given his businesses, it seemed implausible, she implied. Mostly, it went to charity, I responded deftly. I believe he was charitable at heart. She appeared to accept this, though her gaze on me became more scrutinizing. She started monitoring my phone conversations with Harrison, albeit she couldn't hear much as I usually took them in my office with the door closed. The red flag was raised during a dinner party at our house, when she became noticeably more observant. Kevin spoke about his father-in-law establishing a complicated trust fund for his grandkids. David's family did something similar, though not as elaborate, according to Amber. After everyone departed, I inquired about her comment. She replied it was nothing specific. She just assumed there might be more financial resources within the family, which she found out later wasn't fine at all. Over the following months, Amber grew fixated on our finances. She recommended consulting a financial advisor for optimized investments and suggested refinancing the house to tap equity for wealth creation. She also casually mentioned that some of her friends discovered hidden assets during their divorces, which sent a shiver down my spine, causing me to observe Amber's behavior more closely. She was on the phone more frequently and took calls in different rooms. More often, she worked late hours. She appeared remote and preoccupied. Later, I stumbled upon a receipt while searching for a warranty. It was tucked away in her desk drawer. The document turned out to be from Kessler and Associates, a law firm infamous for contentious divorce litigation, not the one that had overseen our house purchase. The consultation cost $500 and was dated 2 weeks prior. That evening, after Amber had fallen asleep, I dialed Harrison's emergency number. "She's seeking advice from divorce attorneys," I informed him. "Are you positive?" His voice remained composed and professional. Finding the receipt, I confided in him. "What do I do?" he advised cautiously. "But David, if she intends to file, we must make sure all assets are meticulously recorded and safeguarded. The trust structure might hold, but we can't be reckless." In the ensuing week, I accumulated evidence. I engaged a private investigator not to trail Amber, but to investigate the law firm she had consulted. What I uncovered was alarming. Kessler and Associates specialize in complex divorce cases, especially those involving concealed wealth. They are known for their assertive discovery methods, unearthing assets that spouses believed were hidden. If Amber was collaborating with them, she believed I held substantial undisclosed assets. At this point, I chose a defensive strategy, working with Harrison to establish a defensive positioning. Any assets that could be moved were shifted further into the trust infrastructure. The house, which was already under a trust but had my name on the mortgage, was restructured to show my ownership as beneficial rather than actual. Every document was amended to accurately reflect the existing situation. I was a beneficiary of the Mitchell Family Trust, not an owner of assets. All purchases, investments, and properties owned were in the name of the Mitchell Family Trust, founded by my grandfather in 1987. For years, the trust held all possessions. 2 weeks following my relocation, we were merely clarifying this ownership. Just as protections were put in place, Amber filed for divorce. Upon returning from work one Tuesday evening, I found her with an attorney, Mitchell Kessler, in the kitchen with a man in an expensive suit. "David," she started without preface, "it's clear that our marriage has come to an end." I maintained a calm demeanor as I took my seat opposite them. "It seems you have already made up your mind," Kessler commented, pushing a document toward me. "We are prepared to propose a generous settlement on Mrs. Carson's behalf." I studied the papers they presented, which required me to relinquish half of our house, consulting business, bank accounts, investment portfolios, and any family money or inheritance I had received or stood to receive. "It appears all-inclusive," I replied cautiously. Kessler affirmed their emphasis on comprehensive preparation. They recognized that your family held significant resources and wished to avoid intricate inquiry, but would do so if compelled. Amber scrutinized my expression, seeking any trace of apprehension or dread. Instead, I nodded contemplatively. "I'll need to confer with my legal counsel," I stated. "Naturally, but David," Amber's tone conveyed a caution. "Don't conceal anything. We have methods for uncovering the truth." Upon their departure, I phoned Harrison. "They had taken the hook," I informed him. "They assume I'm concealing immense personal fortune." "Excellent. Let them believe that until the instant they uncover the facts." The discovery process was grueling. Kessler's team issued subpoenas for bank records, tax documents, business files, and investment reports. They questioned my associates, my acquaintances, anyone who could shed light on my finances. What was discovered matched their assumptions, proof of a man living far beyond what his income indicated. My home's mortgage was under my name, but the payments came from accounts with more funds than my salary could account for. I had made significant purchases that didn't align with my earnings. There were substantial investment balances, real estate transactions, and business interests generating considerable revenue. To Kessler and Amber, it appeared they had caught me in a lie. During a settlement meeting, Kessler informed Harrison, "Your client has been hiding assets." He presented evidence of financial activity indicating a net worth exceeding $5 million. Harrison remained calm, taking notes. "My client has been completely upfront about their finances," Harrison countered. "All the documents you've requested have been supplied." "Do not question our intelligence," Kessler retorted. "The financial evidence points straightforwardly. We're ready to instigate contempt charges if required." However, Harrison responded serenely, "That won't be needed. Yet, I believe a judge should scrutinize the documents first." Kessler didn't grasp that Harrison had been meticulously preparing a trap for 6 months. Each document they summoned conveyed the same narrative. David Carson was a beneficiary of a trust established before his marriage, one that owned significant assets but afforded him no direct authority or ownership rights. The mortgage payments stemmed from the trust. The investments were held by the trust. The business interests were attributed to the trust. Even the house at the center of our dispute was owned by the trust, with David merely designated as a beneficial tenant. Furthermore, as per the prenuptial agreement Amber signed, it contained clauses dealing with trust assets and beneficial rights, waiving any claim to trust property in case of divorce. The hearing was set for a Thursday in late September. Amber was seated with Kessler at the plaintiff's table, feeling self-assured and well-prepared. After spending months constructing what she believed to be an indisputable case against a husband accused of hiding marital assets, she sat beside Harrison, who carried a single manila folder filled with documents that could swiftly end the case. Judge Patricia Hernandez perused the case file before calling us to attention. "This seems to be a disagreement regarding asset categorization and division," she began. "Mr. Kessler, you've claimed that the defendant has concealed significant marital assets. Present your evidence." Over the next 40 minutes, Kessler presented their case. He showed bank records, investment statements, property deeds, business documents, all the evidence they'd uncovered during extensive investigation. "Your Honor," he said, "the evidence is conclusive. Mr. Carson has systematically concealed assets that should rightfully be part of the marital estate, with an estimated value exceeding $8 million. Amber appeared content with the presentation. Judge Hernandez addressed Mitchell. "Mr. Mitchell, what's your response?" Mitchell stood and presented a document from his manila folder. "Your Honor, the plaintiff has indeed highlighted significant assets. However, she's committed an essential mistake in her assessment. None of these assets belong to my client. This is the agreement establishing the Mitchell Family Trust, created by Carson's grandfather in 1987 and funded with his entire estate upon his death in 2015. As you can see on page 12, Mitchell explained, Carson is listed as a beneficiary of this trust, entitled to certain distributions and use of the trust property." Amber's self-assured expression began to waver as she reviewed the document. Judge Hernandez scrutinized the documents. "What about the prenuptial agreement?" he asked, as Harrison presented another document. It was on page 18, section 4, subsection C, pertaining to Mrs. Carson specifically. She relinquished any claim to trust assets, beneficial interests, or future distributions from any trust or estate her husband is a beneficiary of, he read aloud. The courtroom fell silent, and Kessler looked white. Amber appeared bewildered, as if reading an alien language. "Mr. Kessler," the judge said eventually, "you're contesting that your client has a claim to assets she voluntarily waived in a prenuptial agreement she willingly signed? Respectfully, we argue that the assets in dispute were accumulated during the marriage and hence subject to division despite the prenuptial agreement." Harrison interjected, "Those assets weren't accumulated during the marriage, but were acquired by David's grandfather between 1960 and 2015, placed in trust, and have remained property of the trust throughout your marriage. The trust has merely given Mr. Carson the right to use certain assets, as specified in the trust documents." Judge Hernandez looked at Amber. "Mrs. Carson, did you read over the prenuptial agreement before signing it?" Amber's voice was barely audible. "Yes, Your Honor." "Did your attorney explain the consequences of waiving claims to trust assets?" Amber glanced at Kessler, who seemed to be struggling to find a legal loophole. I thought it was just standard language. I didn't realize there were actual trust assets. But you didn't ask? No, Your Honor. The judge perused the documents for a few more minutes before delivering her verdict. The evidence indicates that the assets in question belong to the Mitchell Family Trust, not to Mr. Carson. Mrs. Carson's prenup clearly relinquishes her rights to those assets. She willingly signed it, and it seems a lawyer reviewed it. Mrs. Carson, the court acknowledges this outcome might be disheartening, but you can't now deny knowledge of what you consented to in writing. The prenup stands valid and enforceable. Mr. Kessler, your client waived her rights to these assets. This court won't allow a fishing expedition into a trust established prior to the marriage and over which your client holds no legal claim. 30 days later, the divorce was finalized. Amber received no alimony, no property settlement, no share of any assets. Per the prenuptial agreement, she was only entitled to keep personal possessions brought into the marriage and earnings made during it. Her final settlement comprised her car, personal items, and around $12,000 from her personal account. The house, investments, business interests, all thought to be in dispute, were never mine to relinquish. Post-divorce, I discovered the reasons behind Amber's conduct. The private detective I hired uncovered that she had been involved in an affair with a co-worker at her marketing firm for over a year. They intended to abandon their spouses and establish a new life using the funds from our divorce settlement. Instead, she received nothing, and her lover opted out of a relationship with a woman who couldn't provide the financial stability he had been led to expect. Amber departed Chicago entirely, returning to California to reside with her parents until securing new employment. In the local marketing sector, her reputation crumbled due to public knowledge of the affair and the failed attempt at divorce. However, I continued residing in the house belonging to my grandfather's trust, managing the consulting firm constructed from the assets, living a familiar, comfortable life. The only variation was that now, I could seek someone who would appreciate me for who I am, not what they perceived I could provide. Harrison retired after half a year, but not without modernizing the trust structure first. The revised documents fortify protections against financial attacks similar to Amber's. Upon reflection, I acknowledge that my grandfather's wisdom extended beyond preserving family fortune. He recognized that wealth has the power to transform people and can bring out the worst in those obsessed with possessions rather than relationships. By concealing our family wealth, he provided an opportunity for me to distinguish genuine affection from its absence. I failed that trial miserably, but I long to encounter someone who will pass it someday. The household now seems different, lighter in a way. I'm cautiously and judiciously venturing into dating once more. Time is not of the essence. There's plenty of it for me to find the suitable partner, one who appreciates David Carson, the financial advisor, rather than the secret millionaire. And when I do locate her, she will undoubtedly sign a prenuptial agreement similar to Amber's. Since some lessons are too precious to relearn, that's my tale. At times, the best protection is forethought one may never require, and those who believe they're playing chess might find themselves off the board entirely. If you appreciate this narrative, don't forget to subscribe and click the notification bell, and share your thoughts on prenups and trust structures in the comments. Is it essential for individuals to disclose their family wealth prior to marriage, or are there instances where confidentiality might be warranted? Looking forward to our next conversation in the upcoming video.